One of the challenges that people face in dealing with the division of assets is typically those things that are of biggest value. The complexity under California law is that the characterization of those things sometimes can be mixed. And by that, what I mean is that to the extent value is created during the marriage without a prenuptial agreement, that value is considered a community asset. But to the extent value was created before the marriage and brought into the marriage, that component of an asset is considered separate property. So it's not uncommon for us to run into a situation where you have an asset, whether it's a house, real estate, it may be a business, it could be anything really, and we have a mixture in terms of a component of the asset is considered separate property and a component of the asset may be considered community property. So the question then becomes, how do we figure out what portion is community and then how can it be divided, and to whom should it be awarded if both persons to a marriage are interested in keeping that asset coming out of the marriage. So sometimes it requires that we actually go outside of the legal world and find an expert. If it's real estate, it can involve mixing perhaps an actuary with a real estate valuation expert in order to figure out, for example, what was the value of the asset when the parties got married, how much of that value was equity, and then over the term of a marriage, if it's especially a longer term marriage, maybe 10 plus years, and money was put into the property through reduction of mortgage payments, and the property also increased in value as a result of market changes. So you can have a situation where the market increase value that exists today is a combination of what was owned at the time when the marriage happened, and then part of the increase in the value took place over the marriage. So experts can help us figure out what percentage of the property is enhanced as a result of the separate interest that was in existence when the parties got married and what was enhanced during marriage. And that may in fact be a subject for litigation, because in reality, if we have to go outside of the legal world and get one or two experts involved to explain this to a judge and to document it to a judge, we can have experts that have an opinion, and the opposing side can have experts that have a very different opinion. And so a judge has to sort through the expertise and the opinions that are offered in evidence and then come to a conclusion. The reality is, under the law, the judge really isn't supposed to pick the middle. The judge is legally supposed to pick one or the other, because that's the evidence. The evidence is either A or B. The evidence isn't something in the middle that's artificially created because we have two opinions. But interestingly enough, in my experience, judges don't always follow the rules completely by the letter of the law, and it's not uncommon necessarily for a judge to maybe pick some middle ground and figure out what to do with it. So you may have for a $1 million home, and so $600,000 of that $1 million is separate property and $400,000 is community property. So of the $400,000, that's the part that has to be divided. And then if the person who owned the separate interest before marriage is going to keep it, they only have to come up with $200,000 to buy out the interest of the other side. So it can be complicated. With businesses, it's a little bit similar. If a person owned a business before marriage, the value can really depend a great deal on the nature of the business and what it does. If a business is a product-based business that sells goods, it may be a little bit easier to measure and articulate, but the question becomes, to what extent was it enhanced during the marriage by the efforts of the parties versus more of an arbitrary line that is enhanced just basically based upon market conditions. Sometimes it's a little more complicated because you have a service-based business, and the business is based upon some licensing criteria. So you may have a doctor or a lawyer or a CPA or some person. The business is community. The spouse jointly owns part of that business because it was developed through the efforts of one person to the marriage. But the non-lawyer, the non-doctor, the non-CPA can't own that business coming out of the marriage. So the person who has the license has to basically buy out the interest of the other side. And that can be sometimes one of the most valuable assets. So the question then is how, what other assets are going to have to be traded in order to offset that? So when we're dealing with division of assets in high net worth cases, whatever it is, there can be multiple assets that can be complicated to value. We'll have to construct a spreadsheet and articulate who intends to receive what, and ultimately, develop a column into which assets go to husband, assets go to wife, and balance it. And at the end of the day, if we're close to a 50-50 division of the community portion of those assets and everybody can agree to that, then success achieved. We have an agreement and we have a settlement. If we are not in agreement, a judge is going to have to basically take those numbers, figure out what the actual truth of those numbers is, and that's going to be somewhat arbitrary because ultimately it's an opinion and it's not going to be reality unless something is sold. But the court will take those opinions, take the numbers, split everything 50-50, and at the end of the day, it's going to mean that we have, at least under the law, an equitable division of the assets. So one of the things that people often misunderstand about dissolution is the way the law requires the court to divide assets. And the rule is that whatever people earn during marriage, unless they have a prenuptial agreement, is community property. So a person's time, skill, and talent is community. And so whatever, so if you have a marriage and one person is a high income earner and the other one is not, or maybe one person has no income, they stay at home and take care of domestic responsibilities. People have the concept often that the income earner really should have a right to more of the assets or all of the assets because in their mind they earned those things by going outside of the home and bringing income into the home. And that's just simply not the case. Under California law, the theory is that a couple are united. And when a person is in a marriage or a domestic partnership, that couple represents a single unit. And however the responsibilities are divided between themselves, whatever is earned jointly by one or both of them, it all belongs to the two of them as a couple. So upon separation or dissolution, those assets are to be equally divided. If they can't agree on how to do that, then the court has to, by law, divide those things equally. It doesn't matter if a person has betrayed their marital vows. It doesn't matter if a person's committed a crime. It is completely irrelevant in terms of division of assets. California is a no-fault state, meaning that it doesn't matter why we're in divorce court. If you as a couple own things together, doesn't matter what you did or didn't do to cause a breakup or not, or to save the marriage. Everything is divided equally. Now, having said that, one of the questions we do get in dealing with support is whether or not those things matter. And under the family code, with regard to spousal support, there are rules that would indicate that if a person is in a violent relationship, and there's domestic violence that's taking place, and a person is escaping a marriage relationship as a result of violence, then that is a factor the court can take into consideration in determining whether or not support is appropriate. So if a person has committed domestic violence and they are the low-income earner and would otherwise be entitled to receive support, they're probably not going to get it if they're a perpetrator of violence in the home. And with regard to support, if a person does have access to separate property that would enable them to support themselves, even though that's not something that the court may divide because it's not community, it's not something earned during marriage, that can be a factor the court can look at as it relates to spousal support or alimony. And interestingly enough, as it relates to spousal support, there is a provision in the code that does say that the court has almost unfettered discretion in determining what factors are appropriate to consider in determining whether spousal support is appropriate or not and in what amount. So although the rule as it relates to division of assets is pretty straightforward and there is a no-fault characterization in terms of how those things are to be divided, the caveat is that the companion issue, spousal support, can be affected by those things, and the court can basically exercise what are called equitable powers, fairness powers. What's the right thing to do? To a judge, how do I feel in my gut about how to handle the support question? Sometimes it doesn't seem fair. And just by way of example, I can remember a case very specifically where a client of mine was involved in some litigation, and she really was a victim because her husband, they'd been married over 40 years, and he, as it turns out, had actually molested some children, and she didn't know about it till he was criminally charged and went to state prison. But in a divorce case, he still got half of the assets because they were assets and it was community property and he was entitled to half. He didn't get spousal support from her. He lost his income. He had no way to make a living. Of course, probably didn't need it in being in prison and would be for the rest of his life. But nonetheless, that is how rigid the rule is. No fault is no fault. And so sometimes it can be difficult to understand that and to process that. One of the ways to circumvent that is if going into a relationship, if a person wants to define their rights and obligations and spousal support duties, there is an opportunity to enter into a prenuptial or premarital agreement. We don't see that very often. And one of the questions is, why do I do this? I don't ever plan on having a separation or divorce. And it's our hope that people enter into every marriage relationship with that in mind, that this is a vow, this is a lifetime commitment. But the reality is that at least half of all marriages fail. And the choice is, going into that decision of marrying somebody, am I willing to live by the rules that are set by the state legislature, or do I want to establish rules that I want and have those predefined so that I'm not bound by those rules? And there are parameters in terms of getting that kind of an agreement set up so that it is enforceable, and they're very strict because they're not positively looked at by the court system. But the only way to circumvent what may be interpreted as harshness as it relates to how assets are divided in that context is to agree to do something different than the state mandates and make sure that that agreement is enforceable. And the only way realistically that can be accomplished is with good legal advice, because if any technical mistake is made in entering into that kind of an agreement, the court's going to throw it out and you're going to be right back to where you started with the state rules.